Welcome back to the Untitled Legal Tip. My name is George Sintankwa Malipilo. Tuabuela, back in your ears, Ika. Alright, welcome back. Thank you very much for having us in your ears. Listen to some Happy Rock by Ben Sound. We'll be back in a short while. Okay. Welcome back to the Untitled Legal Attempt. I know you missed this. We missed you. So straight into the show for today. So today's case is a land law matter on acquisition of title from customary tenure to statutory tenure. Now, quick, brief facts in Zambia: customary holding, statutory holding. The president is the custodian of all land in Zambia as provided for by the Lands Act, and the president holds all land. So whatever you do with the land, whether you want to sell it or you want to purchase it, the agreement is always with the president. So state consent, you always have to ask the president, can we transfer? So when you're buying land from the council, it's always in the name of the president. So whatever agreement you make for the land is in the name of the president. You and the president, because the president is the owner, you only have it for 99 years or 100-year lease or agreement. All right. With customary land, it's communal, owned by the people. Now, today's case is Henry M. Siwale, Reverend E. Siwale, Kelvin Siwale, Stephen Siwale, and another Siwale, V. Siwale. So it's a family civil matter on land law. Now, the main argument before the High Court in this matter was that the applicants, because the Supreme Court matter, I think it's Supreme Court Judgement number 24 of 1999, that's the full citation, Siwale and Others versus Siwale, Judgement number 24 of 1999. Now, the main issue was they wanted to be included on the title deed of Farm No. 5032 Nakonde, and they went under Section 11 of the Lands and Deeds Registry Act. Now, the applicants and the respondent were all children of the deceased Donaldo Siwale. Now, Donaldo Siwale had 400 hectares of land, which was given to him by the British colonial authorities in consultation with the chiefs. Now, he never had title to the property, but because he developed it and it was accepted as a homestead of the Siwale family. So people are like, boy, nipariba Siwale pacha. Boy, Siwale property ja boy. Boy, nipariba Siwale pacha. So everyone was like, nipariba Siwale. Now, Donald Siwale had a young son who lived in Lusaka, our capital city. Pa eleske, pa begi, ungapaitane pa menufuna, bati, ni pa begi, umvelaga. Alright, so Donald Siwale had a young son. So he wrote to him and said, look, not the words he used, but, simulation. But he just told him, there's nothing you're doing. Why don't you come back? So the young son came back home, stayed with his dad, and the dad died. Condolences. The dad died. Now, he therefore decided to chase after the acquisition of title to the property. So he spoke to the chieftainess at the time and told them that, he had consultation from his elder brothers, Henry, Reverend, Stephen, and Kelvin, and the other brother, that, he can acquire title for the property. Now, when he acquired title, he was only granted 200 hectares of land, not the 400, just 200 hectares of land. Now remember, this property belonged to all of them. Now, one of his brothers, about employment, obviously about charity, maybe he had a desk job, or was like, you know what, I'm gonna retire. I got a farm. You know what I'm saying? I'm a Siwale. Dad left some property. Let's check it out. Once again, simulation. Don't hold me. So the brother goes and checks on the farm because he wanted to put a borehole and discovers what? The property. Ilipa title. Young brother, iwe mfana. Mama chiki maningi. So you. Once again, these are just jokes. But he discovered that the property was already on title. And they were like, no, we have a right. We have an interest in this property. Why aren't we also on title? So that is how they went to court. In the High Court, they said, look, we have to be included on the title deed. We are the children of Mr. Siwale. Why aren't we included? Now, the High Court said, Ingani is a letter of further problems, guys. Bazambo, menyana. Okay, so the judge in that case said this would bring about further problems, and therefore it was not in the interest of the family that it should include all title. So he held the respondent had the right to acquire the title on the property. Yeah, I know what you're thinking. No, it's not me. It's the judge that's made the statement. So obviously after the case, obviously Mashoko, the young brother was like, pusa mafana, no. Once again, it's just a joke. But obviously they were upset. So when we get back, we will come and hear what the Supreme Court held in that case, and also I'll then blabber about what I think are the important extracts we take from the case. For now, let's listen to some band sound intro because we have no sponsors. Okay, we back to Abuela now. Fire you! Now, in the Supreme Court, you have the judges, the bench. Obviously, there were 3 of them with their robes. Maybe it was hot or something. I don't know. But the judgment of the Supreme Court was first and foremost that the High Court erred in law, and obviously in fact, because these were children of Mr. Siwale. All of them were children of Mr. Siwale. So they were supposed to be on title. Okay? The Supreme Court said the applicants had as much right to be on the land as the respondent. They were all children. So they had as much right to be on that title. That was what they first said. Alright? That they had as much right. 2, they stated that the respondent had stated he did not even consult his brothers, his elder brothers, when he decided to convert the customary tenure and acquire the title. They wanted to state that he even stated to say in his evidence to say, I have full control of the land and I can use its resources. I have the authority to do what I want on the property, and my brothers can stay elsewhere. So, hey, this guy was a donor. But yeah, so the Supreme Court said it was really unfair. I mean, they were family, they were supposed to be included in the title. And they also said that the whole transaction was null and void. Or, I mean, the manner and how, not null and void, sorry, strike that out. The manner and how he acquired the title was not in line with Section 3.4 of the Lands Act. So the president cannot alienate any land situated in an area where land is held under customary law. So without consulting any other person or body whose interests may be affected. He didn't consult them. He did not consult them. That's the first thing. He did consult the chief, yes, but he didn't consult the interested parties. And they were affected, okay, by the grant of the title. Because they wouldn't have, ownership. They were therefore affected, and they were therefore to be consulted before whatever happened. They needed to be consulted. So therefore, the Supreme Court said the respondent should also be included on the title of this. Now, when I get back, I will basically tell you what I get from this case and why it's important and why I decided to talk about it. So, once again, enjoy some Ben Sound music. So refreshing, right? I know. Okay, alright, let's get back to it. So, having dissected the case, the first thing I've understood from Siwale and Others versus Siwale Supreme Court Judgment number 24 of 1999 is all children of the deceased have an interest in a property. They have the right to that property, be it to land or the children. You can't pick one. All of them have an interest in the land, whatever case. 2, there's a difference between statutory land and customary tenure. With statutory land, the president can transfer and alienate it. With customary land, you have to consult each and every person who might, the word might, be affected by the grant Okay? Yes. It is important you have to consult them because your actions will affect them. So this means when you are trying to convert and acquire title for customary land, because it's communally owned, there's no title, people know. Like in this case, they knew that is Donald Siwale's land. Always consult each and every one. Any other person, it doesn't say the owners, any other person or body, meaning it can be a cooperative, it can be a corporation, it can be a company, I don't know, it says body. So I'm just thinking out loud, but it therefore shows natural and artificial persons may have to be consulted. Maybe there's another company that wants to buy. They have an interest, they have a right, they want to buy. So they must be consulted. It's not just you consulting the chiefs, but you also have to consult the other parties. It's important. You also have to read the Land Act as well. Read the Lands Act, Lands and Deeds, and all those relevant acts. But at the end of the day, acquisition of title from customary to statutory is different from statutory land. Statutory land, you seek consent from the president. You just ask. Or you buy from the council, to be the president. When you're transferring between yourselves, you have to ask the president. You apply for state consent. You go to the Ministry of Lands. So there's a difference. With customary tenure, you have to ask the chiefs, but most importantly, consult from all the interested parties that may be affected. So even if you are acquiring title and it's a customary tenure, you can't do it on your own. It has to include all the beneficiaries of that particular title. They have to be included there. If you don't include them, they will use the case of Siwale and Others versus Siwale as precedents to say the Supreme Court ruled to say, oh, the beneficiaries must be included, or they have a right to the land because they are children. So there must be a connection. So thank you very much for tuning in into this edition of the Untitled Legal Attempt. Leave us a comment. Tell us what you think. I'm on Twitter at government name 94, commercial lawyer, wannabe commercial lawyer. Tell us what you want to see. Are there any cases that you want us to talk about? But apart from that, ladies and gentlemen, thank you for being with us, for being in your ears for this amount of time, for teaching you some law. Some law, I'm just joking. But thank you very much. I really appreciate it. And remember, guys, visit Uptony, guys. They're a very good app, and they have these cases. You can read the case of Siwale and Others v. Siwale. It's there, the whole case. I've just summarized it because, like I said, I mean, if I give you the law in its purest form, you'd be bored by now. So, tuma juba guys. Juba. So, tutafaka na papan, na pa frying pan. Alright, so thank you very much. We'll see you next time. This has been your host, as usual, George Chintankwa Malipilo. And we are signing off. And thank you very much. And hope you have a wonderful weekend. Bye.